So the answer to this, the only one that was correct, was at the conclusion of the evidence, the defendant may deliver a summation to the jury, followed by an optional summation by the people. It says the number of peremptory challenges granted in each side in the trial of a B felony is 15, D felony is 10, and C felony is 15. So for D felony, E felony, and a misdemeanor tried in Superior Court, it's 10. Which of the following are true? 1. A challenge to the panel is an objection to the entire panel or a certain part. That's wrong, because it's only the entire panel. 2. Such a challenge may only be made by the defendant and only on the ground that there has been such a departure from the requirements of the judiciary law in the drawing or return as to result in substantial prejudice. Now, make sure if they put this on the test, they have the word substantial in the answer. If it just says result in prejudice, that's not enough. Also, in the local courts, it's not the judiciary law. It's the Uniform District Court Act, the Uniform Civil Court Act. So it's not going to say judiciary law if they're talking about a lower court challenge to the panel. 3. A challenge to the panel must be made before selection commences. True. 4. Such challenge must be in writing, setting forth the facts constituting the grounds. It has to be in writing. 5. If the facts cited by defendant in the challenge are denied by the people, witnesses may be called and examined by either party. 6. All issues of fact and law arising on the challenge must be tried and determined by the court. So the answer that I got for this was B, which was that everything was correct except 1. 6. If no challenge is made or if the challenge is made and disallowed, the court shall direct the names of not less than 12 members of the panel be drawn. The answer is 12. Examination of prospective jurors shall be initiated by A, the court.
Mary, in civil, it's on request. So remember the difference.
On which one?
When you just asked.
Number 7.
So, oh, it's on request in civil. Yeah, because most of the time the judge isn't even there in civil, right? They're not even there. They're in a different floor somewhere.
It's just the attorney.
Yeah. Okay, 200.7, for which, if any of the following defects may an indictment be amended. And the answer to this was the names of persons only. So this is also going to, when we get into family court, I think next week, it's going to be very similar, but there's one that's not there in family court. So when you do JD, just try to maybe go back to this question and remember there's 4 of them in criminal for an indictment. There's legal insufficiency, misjoinder offenses, misjoinder defendants, and the one that's not on this list is failure to state a charge, something like that. This is 9. So after deliberations start, one of the jurors becomes able to continue and only the defendant has to consent. The following must be present during the jury's visit to the scene of the crime. Now the answer here says B, and that's what I got, the court only. I think the other one that it says is a public servant, appropriate public servant. Which, if any of the following are true concerning a defendant's attempt to plead not responsible by reason of mental disease or defect? 1, yes, court's permission required. 2, people consent required. 3, the DA must state, that's supposed to say orally on the record, or in writing, that the people are satisfied that the defense of lack of criminal responsibility would be proven by the defendant at a trial by a preponderance of the evidence. Because that's an affirmative defense. So an affirmative defense is proven by the defendant. So that one I got as true. 4, the defense attorney must state in his opinion that the defendant has the capacity to understand the proceeding and assist in his own defense and understands the consequences of his plea. All of them were true. Which of the following must enter a plea by counsel or corporation? Corporation only, but in civil, it's both?
No, it's civil, you don't plead.
No, it's in appear. You have to appear
By counsel.
by counsel for those two in civil.
Right.
Yeah.
No,
Okay.
It's different about appearing, and this is criminal, and it's
Plea.
appearances and pleas are different.
John V. and Bob R. are to be tried shortly for an offense
Exactly what you meant.
punishable by no more than 4 years in jail. The number of challenges allowed to them is 10, right?
4
It's
years
an
in
E
jail
felony.
means what?
E
A
felony.
D felony, right?
E felony. E
E
felony.
felony. E felony, you get how many challenges? 10. You've been under 2 years.
Okay, now this is the easy way. Number 14. I always wonder when there's 2 defendants and they disagree what happens. But this one had 3 defendants, so it was a majority, then it has to be disallowed. If only 1 out of 3 wanted. But I don't know what they do when it's only 2 and they're disagreeing. They don't? Okay. So apparently if there's 2 and they disagree, it has to be unanimous. 15. Okay, I hate this question so much. Christine, you can come over and go over this one.
Just hurry up.
The idea is that the court can decide where the sworn jurors are going to sit and then keep the unsworn jurors separate from those people. So I think this is a very, very difficult question. I don't think it'll be on the test that difficult. I hope not. Okay. 16. This is the wrong section cited here, so please change it to 270.35, subdivision 2, subdivision A. And this says, if a juror fails to appear or if the court determines there is no reasonable likelihood such juror will be appearing in court within 2 hours of the time set by the court for the trial to resume, the court may presume such juror is unavailable for continued service and may discharge such juror. 17. 280.10. A motion for a mistrial may be made by any of those 3. People, defendant, court, so the answer was A. 260.30. In the trial of an indictment after jury is selected and sworn, the next step is A. The court must deliver preliminary instructions to the jury. 19. Upon a new trial resulting from an order declaring a mistrial, the indictment is deemed to contain all the counts which it contained at the time the previous trial was commenced. B, all the counts which it contained at the time the guy was in, I'm not going to read all of them. It's A. It's at the time the previous trial was commenced, and this is different than some of the other stuff. Okay, so do you want me to say what the difference is or keep going?
No, just keep going. Because
20. 270.30. After the last trial juror is sworn, and then it's the court may direct the selection of 1 or more, but not more than 6 alternate jurors, except if it's murder in the first degree. 21. After the trial of an indictment, the court, 1, may, with the consent of defendant, discharge the alternate jurors. No, that would make sense. But they need the people and the defendant to consent, which is contradictory to the fact that the defendant is the only one that has to consent to replace a deliberating juror, but that is what it says in the book. It says that they need the people and the defendant to consent. And 4, because it's in all cases direct that the alternate jurors not discuss the case and must further direct they be kept separate and apart from the regular jurors. So the way that 21 actually reads out of the book is CPL 270.30. After the trial of an indictment, the court must either, 1, with consent of people and defendant, discharge alternate jurors, or direct alternate jurors not discuss the case and must further direct they be kept separate and apart from regular jurors. (22) 270.35. Before discharging a juror in a criminal case, the court, 1, must allow the people and defendant an opportunity to be heard. Must place on the record the facts and reasons for its determination that such juror is ill, incapacitated, or unavailable for continued services. 23. When 2 or more indictments against the same defendant or defendants charge different offenses of a kind that are joinable in a single indictment, the court may, upon application of the people or defendant, order that indictments be consolidated and treated as a single indictment for trial purposes. The court cannot do this sua sponte. So no consolidation sua sponte. 200.20 subdivisions 3 and 4. In any case where offenses are joinable, but based on different criminal transactions, and the joinability rests solely upon the fact that such offenses are the same or similar in law, the court, in interest of justice and good cause shown, may, upon application of defendant or people, order that the offenses be tried separately. Good cause shall include, but not be limited to, situations where there is 1. Substantially more proof on one, and there is a substantial likelihood jury would be unable to consider separately the proof as it relates to each offense. 2. A convincing showing that a defendant has both important testimony to give concerning one count and a genuine need to refrain from testifying on the other, which satisfies court that risk of prejudice is substantial. Good cause under this paragraph may be established in writing or upon oral representation of counsel on the record. Any written or oral representation may be based upon information and belief, provided the sources of such information and the grounds of such a belief are set forth. Upon the request of counsel, any written or recorded showing concerning defendant's genuine need to refrain from testifying shall be ex parte and in camera. The in camera showing shall be sealed, but a court for good cause may order unsealing. Any statements made by counsel in the course of an application may not be offered against defendant in any criminal action for impeachment purposes or otherwise. A court's determination pursuant to subdivision 4, which is one I didn't read, so let's go back to sub 4. When 2 or more indictments against same defendant charge different offenses of a kind that are joinable pursuant to sub 2, the court may, upon application of either people and defendant, order that such indictments be consolidated and treated as a single indictment for trial purposes. In such indictments, in addition to charging offenses which are so joinable, charge other offenses. If such indictments charge offenses that are joinable and others that are not, they may nevertheless be consolidated for the limited purposes of trying the joinable offenses. In such case, the indictments remain in existence with respect to any non-joinable offenses and may be prosecuted accordingly. Nothing herein precludes the consolidation of an indictment with an SCI. 5. Okay, so that now we can go to a court's determination of an application for consolidation pursuant to sub 4, which is what I just read, is discretionary, except that where the defendant seeks consolidation with respect to offenses which are of a kind that are joinable in a single indictment by reason of being based upon the same act or transaction, the court must order consolidation unless good cause to the contrary be shown. So again, it's a soft must. Okay, effective October 1st, 2018, where an indictment charges at least one offense against a defendant who was under the age of 17 or commencing 10/1/19 under the age of 18 at the time of the commission of the crime and who did not lack criminal responsibility for such crime by reason of infancy, the indictment may, in addition, charge in separate counts one or more offenses that the person is not criminally responsible for. If the offense that they are responsible for are based upon the same act or criminal transaction, or the offenses are of such nature that proof of the first would be material and admissible as evidence in chief upon a trial of the second, or proof of the second would be material and admissible as evidence in chief upon the trial of the first. So, the difference is when you're talking about criminal responsibility by infancy, the only two ways is same act or transaction or proof material and admissible as evidence in chief. Okay, so There's 4 for the regular ones. It's joinable. Generally, 2 offenses are joinable when same act or criminal transaction, different criminal transactions, but the proof is material and admissible as evidence in chief. And then 3 is based on different transactions and not joinable pursuant to B. The offenses are defined by same or similar statutory provisions and consequently are the same or similar in law. Or D, though not joinable with the A, B, and C, each offense is so joinable with the third offense contained in the indictment. In such case, each of the 3 offenses may be properly joined not only with each other, but each of the other 2, but also with any further offense joinable with either of the other 2, and the chain of joinder may be extended accordingly.